All right, well, you want to kick us off?
Sure, absolutely. So thanks for coming today, everyone. I will be your host, your moderator. I am Julie Cortés, copywriter by day, freelance rockstar by night. I live, breathe, coach, speak, and teach on all things freelancing and self-employment. And you may also know me as the founder of the Freelance Exchange of Kansas City. And I'm also an adjunct professor. I created my own course called Freelancing 101, and I teach at the Kansas City Art Institute. But it's not about me today. It's about Chris, our friend Chris here, who is an amazing attorney, loves working with solopreneurs and entrepreneurs. He is the founder of Pixel Law, where he represents anything from startups and freelancers to small businesses. He focuses on day-to-day legal needs such as forming LLCs, drafting contracts, filing trademarks, and more using a fixed fee billing approach. You can learn more about Pixel Law at pixellaw.com. So today we are going to talk about trademarks, what they are, how they differ from all the other sorts of intellectual property, such as copyright, patents, trade secrets, what have you. But for the purpose of this session, we're going to focus on trademarks, and in particular, what they have to do with branding. So if you yourself as a company has a brand, a logo, a name, colors even, or if you are a designer or illustrator and you create that kind of stuff for your clients, this session is for you. So we're going to talk today. Feel free to bring your questions. Chris is going to talk for a few minutes, give a short presentation, and then we'll open it up for Q&A. And, we can cover anything from how to conduct a trademark search, how to apply and secure trademark, apply for and secure trademark rights, and also what constitutes infringement for trademarks. So Chris is here to answer those questions. I'll be monitoring the chat for you, but without further ado, please help me welcome Chris Brown. Whoa! Round of applause. Thank you.
Thank you so much, Julie. For anybody who doesn't know Julie, which is probably not many of you, because I think everybody knows Julie, she's awesome in the freelance world. She does so many cool things for us freelancers. Okay, I'm going to tell you a little bit about myself, and then I'm going to dive into the trademark stuff with some slides. While I'm telling you who I am going to launch this poll for all of you attendees to hopefully tell us a little bit about your business. There's just 2 questions. They're very easy, and this will help me to know how to address different topics that I'm going to talk through here. So go ahead and answer those questions. So like Julie said, my name is Chris Brown. I'm a lawyer. Before I was a lawyer, I was in the music business in Nashville and New York City, but that wasn't really getting me very far. So I ended up going to law school in Kansas City at UMKC Law, worked for a firm for about 3 years in Kansas City, and then started my own firm in 2014. And I've been doing that ever since. And it used to be called Venture Legal. Now it's called Pixel Law. And like Julie said, I work with a lot of small businesses, freelancers, lots of creative type people, marketing professionals, photographers, website developers, and so on. So I have a feeling this topic's going to be a big one for most of you. So I'm going to give you 10 more seconds on the poll. So get your answers in there. And then I don't know if I can share the screen with you or not, but I can at least tell you what the poll results are. So, okay. So first question, how would you describe your business? No high growth startups in here. So we'll focus on the smaller businesses today. A little bit more than half are small businesses and a little bit less than half are freelancers. So that's good to know. And then in terms of what do you do? Oh man, only a few of you said that you create branding elements for market or for clients. Most of you care about your own brand as opposed to the brands that you might be making for people. So that's super helpful for me to know, so we can focus on what you're doing for yourself and not so much what your clients are doing. So let me let me share my screen with you. I've got just about 5 or 6 pages here that I'm going to walk through about what you should know about trademarks, right? So here we go. Why are you not advancing? There we go. There are 4 primary types of intellectual property. We're going to talk mostly about trademarks here today, which will protect branding elements, and I'll come back to that in a minute. There's also copyrights, which will protect mainly creative works. So like these slides that I created, right? As well as music, art, dance, computer code, business documents, all kinds of stuff. Trade secrets, which will protect mainly confidential information. You usually use non-disclosure agreements to protect those, but there's also federal and state trade secret laws. And then patents, which are probably the least relevant for most people. Patents are going to protect inventions for the most part. Like I said, that we're going to focus on trademarks today, so we're going to dive right in. What is a trademark? Well, kind of anything. It's a pretty broad class. The idea is anything that can serve as a source identifier can serve as a trademark. So words and logos are kind of the typical ones that you would think about. There's actually a little, I don't know if you can see this, my coffee mug comes from Patagonia Provisions, and there's a little trademark symbol. It's tiny, but it's there, right? So like the word Patagonia Provisions in connection to selling coffee mugs or clothing, jackets, right? That's a trademark. A logo. So I don't know why I don't prepare better for this, but I always have things on my desk like the Apple, right? That little Apple logo is a trademark owned by Apple for selling computers, right? Taglines, product names like iPhone, for example. Colors and scents can even serve. I think UPS, trademarked their brown color for package delivery. Tiffany, the jewelry company, trademarked their teal color or whatever that is for jewelry. And then sounds even. So like the roaring lion at the beginning of a movie is actually a trademark for movie production. The breathing of Darth Vader is a trademark for the selling of toy costume masks or something like that. It's owned by Lucasfilm. It's interesting. But anyway, anything that can identify the source of your goods or services can serve as a trademark. Words and logos and taglines are kind of the most popular. So then you got to think about how do you choose a trademark, as well as how to evaluate what trademark you already have, because I bet a lot of you already have trademarks and business names. So I like to think of this, and pretty much all lawyers like to think about this as like a spectrum. On the far left, you've got bad marks, right? These are just things you don't want to use as a trademark. They're generic marks. In fact, you can never even protect a generic phrase because it is generic. So if you want to open up Bob's Fast Food, that is an awful trademark. You can't own the word fast food in connection to selling fast food because then nobody else could own it. All right. So I own Pixel Law, but I can't stop other law firms from using the word law, only Pixel, right? So you cannot protect generic names. Don't use generic names. Moving up the chain a little bit, you've got descriptive marks, and these are a little bit better. You can protect them in some circumstances, but it's very limited. Generally speaking, you cannot protect a descriptive mark. And this is a mark that describes the product or service that you sell. Holiday Inn is a great example. So an inn is a place that you might stay overnight, like a motel, hotel, whatever. Holiday is a word for vacation. So it's an inn for people on holidays, right? So it's a really bad trademark. However, Holiday Inn was able to protect it because they've used it for so long that they acquired what's called secondary meaning, which means consumers will identify that phrase as the source of the goods, or in their case, services. But you generally don't want to rely on that, right? You generally want to avoid generic and descriptive and jump into the suggestive and arbitrary. Those are the much better trademarks. Suggestive marks are kind of descriptive in a way, but they require some kind of a jump in the mind of the consumer from the name to the services. So I like the word Coppertone as an example for sunscreen. If I just say, hey, do you like Coppertone? You're probably not going to know right off the bat, what I'm talking about. But if you start to think, oh, in the connection to like going to the beach, oh, you mean sunscreen, right? There's a jump that takes place. And you can absolutely protect suggestive marks. But by far the best mark you can adopt from a legal perspective is arbitrary marks. Apple is a great example. When they launched in the 70s, nobody knew that Apple meant computer, right? They were not connected at all. Nowadays they are, but that's because of Apple, right? So the best trademark you can adopt is an arbitrary mark, but I acknowledge that there's other considerations at play, right? You've got marketing thoughts. If you launch a computer company called Apple, you have to educate consumers that, oh, that means computer, right? So it's difficult. So a lot of times suggestive is the best, even if it's not the best legal, approach. Okay, so how do you run a trademark search? This is a concept of you need to know what's out there before you adopt your name. And there's two places you need to look. One is common law, which is very broad. That basically means anything that's not registered. So search Google, Facebook, look at trade magazines, look at the yellow pages. Basically anywhere that somebody might be using their trade name, you need to be looking to see if somebody's using it before you. And I'll come back to that in a bit. You'll also want to search the USPTO database. That's the United States Patent and Trademark Office website, uspto.gov. If you go there, click on trademarks and click search, you can just search what trademarks are out there. It's actually really awesome. What you're wanting to know is if anybody has registered the name that you want to use. So what you're looking for, and I like to use this example, McDowell's and McDonald's, coming from the Coming to America movie, if you've ever seen that. What you're looking for is a trademark that is either identical or similar to your trademark, used in connection to similar or identical goods or services. So if a client were to come to me and say, I want to open up McDowell's fast food restaurant, I would say, nope, that's an awful idea, especially if you're using like a golden arch and your logo looks the same, right? That awful idea. McDonald's is going to come after you. It's almost certainly trademark infringement, right? Let's say they come to me and say, I want to use it for selling retail ice cream, ice cream in a box that you take home to eat, not like an ice cream cone in a shop. Maybe that might be trademark infringement. Trademarks, McDonald's sells ice cream, to eat in the store, cones and milkshakes and stuff, but they don't really sell retail ice cream. In the real world, I'd say still don't do it. It's probably not worth it, but it may not actually be trademark infringement. And then let's say that a client says, I want to sell McDowell's greeting cards. Okay, I don't have a problem with that, right? At least in connection to McDonald's. There might be another McDowell company out there, I have no idea. But in connection to McDonald's, they don't sell greeting cards. They don't have anything to do with greeting cards. You could probably use it and not have to worry about McDonald's coming after you. So again, a similar name or an identical name used in connection to similar or identical goods or services is what you're looking for. And anyone who used it before you probably has superior trademark rights over you. So you need to be very cautious with adopting a name that somebody else has already started using. Conversely, do you have a question, Julie?
Yeah, Chris, sorry to interrupt. We've got a question in the chat here. Sheila is asking, as an author, will I need to trademark my book title?
A book title probably will not serve as a trademark if it's only one book. I've actually done this for a couple of people, and I can't remember the specifics of it. I think if you have a series of books, then yes, you can trademark that. So like Harry Potter, for example, is a series of books. So I believe Harry Potter is probably a trademark. In fact, somebody should go to uspto.gov and search it right now. There's probably hundreds of them. But if you have a series of books, I'm pretty confident you can trademark the title. If it's just one book, then probably not. Okay, great. So I was saying that you need to see if anybody else is using a trademark before you adopt your trademark, because first use is generally how trademark rights come about, is the first company to use a trademark in commerce. So if you flip that, you got to think about, how do you acquire trademark rights, right? So the same principle applies. You can get what's called common law trademark rights just by using a name in commerce. You don't have to register it. You can just say, I've been using this name for 5 years, and Julie just showed up yesterday and started using the name. And you can go to a court and say, Judge, stop Julie from using this name. I've been using it for 5 years and she just started using it. And you would probably win, right? You can use the little TM, so superscript or whatever, next to your name to claim trademark rights. But keep in mind your rights are limited to where you use the trademark. So if I open up Pixel Law in Kansas City, and then somebody in Portland opens up Pixel Law, and I don't have anything to do with Portland, and I never sell services in Portland, and I don't register my mark, somebody in Portland might be able to open up a Pixel Law, and I might not be able to stop them, right? But I do want to stop them, right? I do have a nationwide practice to some extent. In particular, trademarks, I represent people all over the country. And so I do want to stop them. So the way you do that is you get a federal registration from the USPTO. Again, that's the United States Patent and Trademark Office. In doing this, what you get, assuming it gets cleared and approved, is nationwide trademark rights, right? You can then use the Circle R logo, and you're claiming a federal trademark registration. So then if somebody a year from now wants to open up a Pixel Law in Portland, Oregon, I could say, nope, stop. I have a federal registration. I've used it before you, and you have to stop doing that. And I would have a very good argument against them. Now, if you're not actually using the name yet, so you're just thinking I'm going to launch next year, you can also file what's called an intent to use application to hold your spot in line, basically. But at some point, you have to prove that you're actually using the trademark to get those rights. And if anybody has any questions on that, we can come back to that in the chat. So that's kind of where I'm going to stop here. Actually, let me mention trademark infringement. I don't have a slide for it, but Julie reminded me in her pitch that I was supposed to talk about infringement. So trademark infringement occurs, and I'm going to back up here. Trademark infringement occurs when somebody without authorization uses the same or an identical mark on the same or similar goods and services. So I kind of did cover it a little bit with the McDonald's example here. So again, if somebody opens up McDowell's greeting card company, it's probably not infringement, right? Because greeting cards has nothing to do with McDowell's, and McDowell's is not even identical to McDonald's, right? But if you open up a fast food restaurant or a food truck or even a grocery store, I'd say, you got to be cautious because somebody like McDonald's is going to fight for their trademark rights. So that's where trademark infringement happens. Normally, you don't get sued right off the bat when trademark infringement happens. Normally, you receive a letter first, and the letter is going to say, hey, stop using this, right? And more formal language than that, but that's the gist of it. When you get those letters, call me or a lawyer somewhere that knows trademark law, and they can, they can talk through the fact pattern that you're in to see if it's actually a serious risk or not. Sometimes it is, and the unfortunate thing is then you have to change your name. So doing all this upfront research can be helpful to avoid you getting those letters in the future. And then when you flip it, if you find somebody using your trademark, you have to send them a letter, right? You need to police the market, especially if you have a trademark registration, because if you don't police the market and lots of people start using your name, the mark can actually become generic and you can lose trademark rights. So I think it's escalator, or elevator, I forget which one, was invented, I think, by the Otis company, and they called it an escalator. And then everybody else started calling moving staircases escalators, and they lost their trademark rights. And so now they can't protect that anymore because they allowed everybody in the market to use it, and it became the generic phrase for a moving staircase. Same thing with Murphy beds, those beds that like fold down from the wall. They lost their trademark rights because they didn't police it. So all right, I'm going to stop this share screen. So I wanted to leave plenty of time for Q&A. I love Q&A. I know Julie's got some questions. I see there's some chat stuff going on, so I'm guessing there's questions in there. So Julie, I'm going to hand it off to you and let you kind of run the show. Let me know what you think I should be responding to.
Sure. So Kay, the initial apparently, is asking in the chat here, what happens when you have an intent to use and do not use it? How do you get an extension, and when will it be finalized as a trademark?
Good question. So when you file an intent to use application, I think if I remember right, the document says you have a bona fide intent to use the name in the next 6 months, if I remember correctly. The practical reality is the USPTO right now is taking about 7 months to review an application. So if you file a trademark this week, you're not going to get a response until I think June, if I remember correctly. Let's just say that they say, yes, your mark is good, you can register it. Then it goes through a public opposition proceeding for 30 days where the public gets to object to your trademark. If it clears that, then at some point you'll get a letter from the USPTO that says, okay, your mark is approved. Now you have to prove use. That process takes like 9 to 12 months, right? So you have a pretty big window, practically speaking. After they say, okay, now you have to prove your use, you have to start using it within 6 months of that date and file that evidence. The filing, I think, is $125 to prove your actual use. And if you're not using it within that 6-month window, you can file a different document, which I think is also $125. Actually, no, that filing it to prove use is $100. Filing for an extension is $125. Anyway, you can extend it for 6-month windows. And I think you can do that for up to 2 years or maybe 4 years. I can't remember. I've never had anybody go beyond one extension before. So anyway, you extend it until you actually prove using it. If you never use it, the application will become abandoned, and then you just lose it and you have to refile if you want to try to get it again.
Great. We've just had another question come in. Perfect timing from, if I'm going to say this right, Rionda. I visited the USPTO site last week. Did I understand correctly? We are required to use an attorney to complete the process, whether the simple method or complex application.
No, I don't think so. I think there might be a new rule that if you're outside of America, you might have to use an attorney. I think that's a new rule. But if you're in the USA, and certainly if you're a US citizen, I think you can do it on your, or I know you can do it on your own. Lots of people do it on their own. I mentioned earlier, there's different types of intellectual property. If you're doing a patent, you have to have an attorney. I think literally you can't file it on your own. If you're doing a copyright, you can absolutely file a copyright on your own. Just go to the Copyright Office website. It's like $50. It's really easy to do. Trademarks, though, it's right in the middle. I would say, I mean, yes, you can do it on your own. There's no problem with doing it on your own necessarily. But trademark law is so not intuitive and complicated. And I mentioned all those long time periods and waiting periods. I've had a lot of clients who file it on their own, and then they call me like 9 months later, hey, I got this denial and I can't figure out why, right? Sometimes I'll look at it and I'll say, man, if you would have run a trademark search and asked me, I could have told you that 9 months ago, right? Or sometimes I'd say, well, you could have changed your application this little way to get it through, but now it's too late, right? So the point is, yes, you can do it on your own, but with trademarks, I usually say you should work with an attorney just to avoid all those problems, because you don't want to wait 9 or 12 months to get a rejection for something that could have been resolved by the attorney up front.
Thanks, Chris. We've got a question in the Q&A. Jasmine is asking, can you go over the last slide again, please?
Yeah, let me, whoops, don't want to do that. I think you can see that now. Should be able to. The last slide. Okay, how to obtain rights. So I'll just kind of go through this a little bit quick, but also feel free to screenshot it. When you start using a trademark in commerce, so you open up your store, you launch your website, whatever, you can claim common law trademark rights, which means you can go to a judge and ask a judge to enforce your rights against somebody else. And that's great. And you can use the little TM and everything. But there's lots of limitations to common law trademark rights. And generally, I recommend you do not rely on them. I mean, you can, legally it works, but it's not the best strategy. Ultimately, what you want to do is file a federal trademark registration. And that's kind of what I was talking through a couple of minutes ago. And that's when you can go to the USPTO.gov website or just Google trademark office. And you can go through the steps. Like I said, you don't have to have an attorney. You just fill out the forms, submit evidence of how you're using it, explain what goods and services that you're selling under the mark, click submit, pay your $250 fee, and away you go, right? And that trademark registration is extremely valuable today. More and more trademarks are being filed every day. I can't remember the numbers, but there's something like 180% increase in trademark applications in the last year. And a lot of that's coming from China. I won't get into all the boring details, but it's really weird. What was I going to say? But as a practical strategy, let's say you're launching your business on January 1st and you've got $10,000 to invest in your business. And you need to buy a domain name and build a website and buy business cards. And you have all these things to do. Are you going to spend $1,500 on your trademark? Maybe not. Maybe it doesn't make sense yet, right? So you can rely on common law rights for a while, and most of my clients do. But after you've been operating for 6 months, a year, 3 years, or whatever, and you start realizing like, hey, this business is legitimate, it's going to survive, that's when you want to file your trademark registration from a practical standpoint. If you can afford it up front, I always say do it earlier. The earlier you file, the better, but you don't necessarily have to. All right, I'm going to stop that share.
Crystal made a note saying it's hard to get a hold of anyone in their office. Do you happen to have any tips to get a hold of people?
You mean attorneys?
In the office, in the, what did you mean?
Oh, you mean the trademark office?
Trademark office, yes.
Oh, there's a generic phone number you can call. I don't remember what it is, but there's a generic phone number on the USPTO website, and I have no idea how responsive they are right now. They are so far backed up. Pre-COVID, they would take 3 months to get a response. Today, they're taking 7 months.
Oh my God.
I mean, it's just insane. So I don't know how effective that phone call is going to be. If you've already applied and you got what's called an office action, which is kind of like a rejection, the rejection letter is going to, well, first of all, it'll be emailed to you, most likely. When you get the email, it's going to have a whole bunch of information in it about why it's being rejected. And at the bottom of that email, almost the very bottom, will be the signature of the examining attorney. And there should be a name, email, and phone number for that attorney. And you can just call them, pick up the phone and call them. Remember, they're not going to give you legal advice. If you're not a lawyer, they might limit what they say to you because they don't want to get in trouble. But they will answer the phone or at least call you back. And if you're still struggling, have somebody like me reach out, because I have a feeling they're more responsive to other lawyers I'm not saying they won't respond to you. I'm just saying I have a feeling they're more willing to talk to somebody like me because I know this topic well, whereas a novice might not know enough to even know what to ask them. So anyway, that's how you get a hold of them.
Okay, great. We have a ton of questions coming in. So I want to keep us on track here since I know we only have a short amount of time. Sheila, the one who was asking about her book earlier, says, in regards to my book, I would like to put my book title on merchandise, shirts, cups, hats, etc. Will I need to trademark at that time?
Again, you don't have to file the trademark. No, you can rely on common law rights. And so if you're a brewery, for example, or let's just use the author as an example. If your core product is selling books, let's say you write a series of 10 books, by all means, trademark the title of the series. That's a great idea. Let's just say that you make 5% of your income selling t-shirts related to the books. I mean, the t-shirts aren't your core business. Do you really need to file a trademark for that? I don't know. I mean, it'd be nice if you've got plenty of money and time, by all means. It's not a bad idea, but it may not be the best business strategy to do it. But also keep in mind, and I haven't gotten too much in depth on this yet, but it's a good point. When you file your trademark, you have to designate what goods and services you're selling. So there's predefined descriptions you can use, and they're usually you'll want to use those. I'll just show you what that looks like. I love Zoom because I can just share my screen and it's so much more useful.
I totally agree.
So if you Google US, or you might copy this link, it's kind of long, USPTO Goods and Services Manual, or I guess they call it the Trademark ID Manual. If you Google that, you can get here. So if you were to search for like books, 372 results in all kinds of different classes. So this class 41 is a service class. I use it a lot. Publishing of books, ebooks, and so on. That's the service of publishing books, which is different than selling scrapbooks. If you're selling a physical product, that's going to be a class 16. Class 16 and 41 are obviously different. There's I don't know, about 50 classes. So when you file, if you do one for selling books or selling or serving as an author, that's going to be a different class than selling t-shirts. T-shirts is going to be a whole nother class. I mean, oh, that's not right. 103, oh, actually, not that many, 103 for shirts, right? But that's class 25, right? So what I'm getting at is every time you add another class, your application fee goes up. It's $250 per class. Also, when you add classes, it means that when the trademark company or trademark office runs their search, they're going to be searching for all these other things. So you want to be cautious. You don't want to file a billion classes because it'll cost a bunch and you'll get an office action. But you also want to be as broad as you can be to extend your rights. Facebook, when they changed their name to Meta the other day, filed a trademark where they had the craziest list of services I've ever seen. Somebody shared it on Twitter and it took like, I don't know, 8 photos to share all the services. It's absolutely insane what they included. Okay, anyway, so you would want to come in here and search for the different types of things that you'd be selling: shirts, beer, books, whatever.
Awesome.
Cool. And that's all I've got for that one.
Oh, okay, good. You're done? I'm not sure. Okay, cool. All right. Risa asked, she also visited, what is the difference between 66A T's standard and T's plus?
Oh, yeah, I don't know what 66A is. That's probably a reference to the statute, but the difference between T's standard and T's plus is how you file. I can't remember if they have a chart. Yeah, the chart's not where I thought it was. I think they've got a chart somewhere. But anyway, T's standard is kind of the old way of doing it. I think you still have to do it online. I think there's actually 3 ways of doing it. I can't remember what the other one is. There's one that you can do by paper, and they charge like $500 or something. Don't do paper. There's no reason to do paper. T's standard is what you use. Well, let me do it the other way. T's plus is what you use if you can use a predefined good or service like I just showed you. So if you can copy and paste that, you agree to do everything electronically. Those are really the only 2 big ones. If you agree to those 2 things, you can use T's plus, and I think it's $250 per class. If you can't do that, so if you cannot find a pre-approved description, which is highly unlikely. I mean, I almost always find one, but if you can't find one, or if you don't agree to do it, electronically. Then you have to file a TEAS standard, I think it's called, if I remember right. And then I think they charge like $275 or $300 per class. It just gets a little bit more expensive. But honestly, most people can get under the TEAS plus requirements. It's not hard to meet those.
Great. Okay, BK says, I've been reaching out to lawyers and have not gotten any response about trademarks and intellectual property. Are you available for a one-on-one consultation?
Oh, sure thing. Yeah, just here, I'll put my email in the chat. It's just chris@pixellaw.com. Yeah, by all means, reach out to me and we can talk. I've also got an ebook that I'll share with everybody in here tomorrow or later today. I'll just email it to everybody so you can get it. The ebook's going to cover a ton of stuff about trademarks, but also copyrights and all the other areas.
Chris, I know you're recording this, but we've had some requests for the slides as well. Can we include all of that in the email that you're going to send out to everybody?
Yeah, I can put the slides in there, no problem. Yep. And if I remember right, Julie, are you going to post this on YouTube?
I can post it, yeah, I can post it on my YouTube channel since I have one, and you can include the link. That's totally fine.
Yeah, let's do that. So we'll put this video on Julie's. Is it the Freelance Rockstar channel?
Yes.
Okay. Yeah, we'll put it on Julie's channel and everybody can access the video later.
Well, yeah, send the link in the email. So perfect. Okay. Rianda, I hope I'm not butchering your name. Could you give an explanation of trademark versus service mark? That's a good question.
Yeah, I almost always talk in terms of trademarks, but technically there is a difference. Trademark is technically used for selling goods and products. I don't think it has to be physical. I think even digital products, like I sell contract templates online, I think I could use a trademark for that. If you provide a service, then you technically have a service mark. So I mentioned earlier, class 41 is a service, whereas class 16 is a good, right? So if you provide a service, you can call it a service mark. And I think you can even use an SM instead of a TM. But for almost every purpose that we'd be talking about, you can just use TM and call it a trademark. You don't have to get that granular.
Awesome. All right. Richmond is asking, I'm currently developing an online game. How would you advise me to protect my game assets? Something to note, he's not based in the United States.
Oh, okay. Well, I have no idea where you live, and I also don't know a ton about international copyright laws, but I can tell you how it works in America. And I can tell you that a lot of countries are very similar to America in this regard. Not all of them, but I bet most are. To protect the game, that's going to be more about copyright, which I'm happy to talk about. So copyright, like I said earlier, protects creative works, whereas trademarks will protect the branding, your branding elements, your name, slogan, taglines, things like that. Copyrights protect the creative works, music, art, dance, movies, all kinds of stuff. It also protects business documents, presentations. So my presentation I gave here today, I could in theory copyright that, or actually I already have copyrighted it because you obtain copyright as soon as you create the work, kind of like you get trademark once you start using the name. Anyway, so copyright will protect the creative works. So when you think about building a game, an app or whatever, what you have is the visual aspect of the game, which is, the front end, the UX and, the designs of the pages and the flows and the characters and all that stuff. And then you have the back end, which is all the software code. And you can copyright all of that. It's all creative in nature, and you can get a copyright for all of it. You don't have to register with the Copyright Office, but I highly recommend you do register with the Copyright Office if what you're doing and selling is the copyrighted work. What I mean there is I have ebooks that go alongside my law firm, but I haven't filed those copyrights because I don't even charge for them. That's not my core business. I could file those copyrights. I just never got around to it. Right? That's not my core asset that I sell. So I just don't care. But if your core asset is a game, I would copyright it. Somebody asked earlier about using a lawyer versus not. You don't have to use a lawyer to copyright your stuff. It's probably a good idea to use a lawyer, but it's a lot easier. You go to the Copyright Office website, pay the $50 fee or whatever it is, upload a copy of the work, click submit, and that's kind of all there is to it. But anyway, so what you probably want to focus more on is copyright. And if you don't live in America, you just need to look up your copyright laws in your local jurisdiction. You could probably also copyright it in America, even if you don't live here. I don't know the full scope of that, but you might want to check out doing that just because I presume you'll have customers in America, so it's not a bad idea to do it.
Awesome. Well, that leads me to the one point that I wanted to make sure I made throughout this entire presentation.
Yes.
And that is the difference between a copywriter, what I do, and copyright, what you're talking about. So I'm going to put that in the chat so you all can see the difference of spelling.
I was about to type that.
Yeah. So a copywriter, what I do is essentially I write copy, which is promotional words. I work in advertising and marketing. I write websites, brochures, TV commercials, anything that's advertising or marketing related. But I can't tell you how many people confuse the two words and how many people come to me and they're like, hey, Julie, I need a copyright for my logo, my brand. I'm like, you need an attorney. Like, I can't help you. So I just wanted to make that distinction really clear to everybody here.
Yeah, I think that's funny. Let me actually interrupt too real quick.
Yeah, go for it.
I know that we're talking mainly about the legal stuff, and a lot of you already might know this, but like your branding matters, right? Look at Julie's hair, right? She's got that purple stripe. When I see the color purple, I think of two things. Ironically, my law firm, because I use purple too. But anytime I see purple in the context of like a creative field, I think of Julie, right? Because Julie uses purple everywhere. I think her wall might even be purple or pinkish or whatever, but like
not just the hair,
but like your logo, your website, like you've got that backdrop. You've used marketing materials I've seen before. You showed me one the other day with like a purplish, cloudish background or whatever. Oh yeah, right there. And that branding is so valuable because I identify and think of Julie when I see that kind of stuff, right? So the reason I chose purple for my law firm years ago was because no other law firm uses purple. Every law firm in the world uses blue. I don't want to look just like every other law firm, so I made mine purple. It had nothing to do with Julia, just coincidence. But so it helps you stand out. So anyway, not only is it important to legally protect your trademarks and your branding elements, it's important to think about making yourself look different. And I'm just saying this as a small business owner and a freelancer myself. You've got to make yourself stand out, which Julie does a great job of doing. So anyway, yeah, let's get back to questions.
Okay. Kay is asking, so the intent to use, does that mean it was approved or is the intent to use the final step?
The intent to use is just a basis. The USPTO calls it a filing basis, and there's a whole bunch of them. There's like a basis, meaning that you've applied in a foreign country and gotten it registered there, so now you're just moving it here. There's all kinds of bases. The two most popular bases are 1A and 1B. 1A is actual use in commerce. That means you've already started using the mark. You can prove you've already started using the mark, and you're going to file a registration. You're going to file an application under that basis. You're going to say, I'm already using it. I want to own it. Then you've got 1B. 1B is intent to use. And when you file your application, what you're saying is, USPTO, I intend to use this trademark in the next 6 months. But like I said earlier, it's kind of more than 6 months. Anyway, what you're doing there is you're telling the USPTO, I'm not using it yet, but I want to hold my place in line. Right? And then you have to come back later and make another filing to prove your actual use. So a 1A actual use application is one filing. A 1B intent to use application is two filings. They're very similar, but just a little bit different.
Interesting. Okay, we've got Varsha here saying, hi, I'm in, what is WOSB, Woman-Owned Service Business? Is that right? WOSB, who is planning for a product manufacturing based within the country. This product is not exclusive or unknown, but I don't think it's been made in bulk in our country. Do I have to do anything special to protect my product and its manufacturing process?
Yeah, when you say our country, I don't know if you mean America or not, but that's largely all that I can talk about, just because I don't know a ton about other countries' laws. What you're talking about, oh, in the USA, okay, great. What you're talking about is trade secrets, and I mentioned that just briefly when I first started out. This is not so much trademark. Trademark involves the name. So if you want to protect your business name, you can file, again, an intent to use application to say, I'm going to use it in the future. I want to own it. And you can file that. But more so what you're talking about is trade secrets. And I'm happy to talk about that too. So trade secrets are your confidential information. It's your business processes. It's your manufacturing plans, your pricing list, your customer list, all that stuff, right? There are federal and state trade secret laws you can rely on. So like, let's just say that I somehow got access to your files and I'm like, oh, that's a great idea. And I go off and I rip off your idea and I start producing it, right? And I stole your info. It's called misappropriation. And you could come after me under various state laws, state and federal laws. But more likely what you want to do is use non-disclosure agreements. So as you start to talk with manufacturers, as you start to talk to designers, as you talk to anybody who's involved, Say you go to Julie and you say, Julie, I want you to help me make all of my marketing copy and flyers and papers and stuff. Have Julie and those other people sign a non-disclosure agreement. The non-disclosure agreement will say, hey, we're going to work together on this product or this project. And it will say, Julie, you will not use my information for anybody else's benefit, and you will not disclose my information to anybody else without my permission, right? And then if she does that, then you could sue her for a breach, not only of the laws, but of the NDA, and she'd be liable for all kinds of damages. So if Julie had come to me and said, Chris, I'm working with this woman, she's got this awesome idea, I think you should go off and produce the same thing, here's the design plans. And then I do that, well, Julie's going to be liable for all that, right? Because she signed an NDA, and Julie would never do that. But anyway, that's the idea. So you're going to want to rely on non-disclosure agreements if your concern is people stealing your confidential information.
Awesome. Thank you. Well, I have a question for you. Is just since I work so closely with designers and illustrators, so I'm going to be coming from that vantage point, but I know those service providers are always, when they work with their clients, the clients tend to want to have ownership of everything the designer creates, right?
Mm-hmm.
And I know you have said in the past, like, well, wait a second, you want to be very careful about how much ownership you give up. So what's the fine line there? What's the ideal situation to have a win-win situation for both designer and client?
Yeah. So there's two things, trademarks and copyrights. Patents and other things are relevant too, but trademarks and copyrights are the big ones. First thing to remember is trademarks will protect the branding elements, but only for the people who are using it. So I know Julie doesn't do this, but let's say that she made somebody a logo, right? Julie doesn't own the trademark in that logo. She's not using the logo to sell anything. It's the client that's going to use the logo, right? So Julie might have a copyright, but I'll come back to that in a minute. What the trademark relates to is the use of the logo to sell stuff. So the client owns the trademark, right? In terms of the contract, between the two parties, what you need to talk through and document is the copyright ownership. So the copyright to the logo, the copyright to the branding elements, the copyright to the marketing copy, the white papers, whatever it is that she's creating, you need to document who's going to own that. So if she's making a white paper for a client, it's probably fine to give ownership, copyright ownership of the white paper to the client, because she's probably not going to reuse that anywhere, right? So the contract can say, somebody will pay Julie 10 grand, she'll make a white paper, deliver it to the client can then own the copyright and do whatever they want with the white paper. But let's say that Julie is a website designer and Julie builds 5 WordPress themes, and then she uses those themes for all of her clients. It's a bad idea for Julie to give ownership, and when I say ownership, I mean copyright ownership of the WordPress theme to the client, because then she can't duplicate it. She can't reuse it. She can't create derivative works from it. She can't reuse the template that she built for her other clients. And that's a significant problem. So normally in those situations, what I do is I advise clients and I help them draft language that says that the freelancer, Julie, owns the underlying assets, basically the WordPress theme. But to the extent she creates anything unique, maybe she writes a bio for somebody on the website, those unique one-off elements will be owned by the client, and they can take it and use it, however they want. But she'll continue owning the WordPress theme and just grant the client a license to use it. And it might be a perpetual license. It might be like, hey, client, even if you fire me, you can keep the website all you want, but I own the copyright, so you can't duplicate it and so on, so that Julie then can keep reusing it. So anyway, that's kind of how you do it. The most important part here is to keep in mind when you're doing a contract with a client and you're creating anything in a creative element, talk through intellectual property and make it clear in the contract who owns it. That'll just help you avoid all kinds of disputes.
That's great. I'm going to put here in the chat here, if anybody needs help, if you need a designer or an illustrator, the Freelance of Kansas City serves as a free resource offering. We've got 175 members in there. We've got designers, copywriters, photographers, what have you. And you can go and search our membership and find a designer to help you with those kind of assets. And it's all free for you to use. So let me put that in the chat here.
While you're typing that, let me also hype up one more thing. Freelance Exchange has free events, or I don't know, I think some are free, some are paid, some are for members only. I can't remember exactly, but they have all kinds of cool events. I've attended them, I've spoken at them, and it's just a bunch of creative people that get together for lunches and coffees and presentations and all kinds of stuff. So check them out if you want to attend those, and they're awesome. It's a really great way to learn stuff.
Thank you for the plug. Well, we are running short on time. I do see one question in here, one last question from Barsha, who is saying thank you. Can anyone outside the country be liable for stealing the trade secrets or processes?
Yes, but it gets complicated, right? Because say somebody in China steals your trade secret, it's hard. What are you going to do? If you're Coca-Cola, yeah, you're going to go after them pretty hardcore. You've got plenty of resources to do that. If you're a small business, you're probably not hiring a lawyer in China and filing a lawsuit. Even if you have an NDA in place, you're still probably not doing it. It's cost prohibitive. They're not great about protecting intellectual property anyway. So yes, use contracts with those people, sign NDAs with those people, do everything you can to try to protect yourself, but just keep in mind that it may be really hard to enforce your rights against them in a foreign country. Therefore, use a lot of due diligence and think through who you're working with. Try to get good referrals to make sure that you're working with trustworthy people overseas. That's really kind of the short answer.
Perfect. Any other questions you all have for Chris before we let you all go this morning?
Yeah, and while they're thinking and possibly typing, let me just remind you, what I'll do is I'll share an email probably tomorrow that'll have an ebook about intellectual property. It'll have a link to this video, hopefully, and the slides that we talked about, so that you can all refer to that stuff later. But yeah, so anything else, Julie?
No, I think that's it from my end. And from what I'm seeing in the chat, Varsha says, thank you. You guys were great. So
awesome. Well, thank you all so much for coming. I love doing this. It's a lot of fun. I love doing Q&A stuff.
awesome. Thanks so much, Chris. Appreciate having you this morning.
Sure thing. All right. Bye, everybody.
Bye-bye.